Our final segment addresses differences in philosophies of constitutional interpretation. We can kind of see this philosophy on display in the tension between two current members of the Supreme Court. We have Justice Stephen Breyer, who's photographed here on the left, and Justice Antonin Scalia, photographed on the right. I'm going to be drawing a little bit from a book called The Oath, the Obama White House and the Supreme Court, written by Jeffrey Toobin. So if you see any specific page references in parentheses throughout the course of the notes that follow, they are coming from this particular book. One thing we need to bear in mind when we talk about Supreme Court cases is the importance of precedent. There's a phrase in Latin, stare decisis, which translates as let the decision stand. In the English common law system, judges generally followed and built upon a series of precedents built up over time. The idea was to foster continuity in decisions over time and a gradual evolution in the law. And for the most part, American judges have imported this tradition, that we still give considerable weight to the principle of stare decisis, that we shouldn't have gigantic conceptual leaps from decision to decision or from case to case, that judges are bound to follow the precedents set by earlier decisions. That's not to say, and that's important to emphasize, it is not to say that precedents can never be overturned, but precedents should be given significant weight in decision making. Now, there are a few different philosophical interpretations of how to deal with the issue of precedent. And I'd like to draw for a moment from a famous speech given by Justice William Brennan in October 1985. Justice Brennan was appointed to the court by Dwight D. Eisenhower in 1956, and he served on the court until 1990. He's considered one of the preeminent liberals of the 20th century to serve on the Supreme Court, and he was somebody who very clearly articulated a philosophy of the living Constitution. And he said this in his speech in October 1985. We current justices read the Constitution in the only way that we can, as 20th century Americans. We look to the history of the time of the framing and to the intervening history of interpretation. And there he's alluding to the principle of stare decisis when he says, we look to the intervening history of interpretation. But the ultimate question must be, what do the words of the text mean in our time? For the genius of the Constitution rests not in any static meaning it might have had in a world that is dead and gone, but in the adaptability of its great principles to cope with our current problems and our current needs. Those who embrace the idea of a living Constitution begin with the premise that the Constitution contains unenumerated rights. And when I say unenumerated, that means that it's not specifically listed in the Constitution. Toobin's book says that even if a right was not specifically mentioned in the Constitution, the court could draw upon the implications of the explicit provisions of the Constitution, prior decisions, and the broader evolution of American society to expand the liberties of Americans. For example, Justice Louis Brandeis, as early as an article in the Harvard Law Review in 1890, alluded to a constitutional right to privacy. Now, if you read the Constitution from beginning to end, you will find no specific listed right of privacy, either in the body of the Constitution itself or in any subsequent amendment. Okay. But Brandeis argued that the various rights of the Constitution, when interpreted together, imply a right of personal privacy. Justice Oliver Wendell Holmes, 30 years later, in a case called Missouri versus Holland, said, "The case before us must be considered in the light of our whole experience, and not merely of that was said 100 years ago." So Justice Brennan might be one of the more recent and more prominent supporters of this idea of the living Constitution, but others, like Justice Brandeis and Justice Holmes, in the late 19th and early 20th century also adhered to this particular view. A different perspective is textual analysis, or textualism, more simply put. It's usually associated with Justice Scalia on the contemporary Supreme Court, and Scalia at this point is the longest tenured member of the Supreme Court currently sitting on the bench. Scalia's perspective is that when it comes to interpreting Constitution and applying it to modern day cases, the intellectual, moral, and personal perceptions of judges should not matter. Here's a textbook example of the textualist perspective, and Scalia wrote the majority opinion on this case. This is a case called Coy versus Iowa from 1988. And this involved a man who had sexually assaulted two 13-year-old girls in Iowa. When it went to trial, everybody involved wanted to prevent this man from being able to see these girls, and they also wanted to prevent the girls from having to see this man. So they put a screen in place between the man and the girls at the trial, so he couldn't see them. Scalia's majority opinion said that this was unconstitutional because the accused, even accused child molesters, have the right to be confronted with the witnesses against them. Because the man was unable to see the girls and they were unable to see him, he was deprived of his right to literally be confronted with the witnesses against him, and the court overturned the conviction of this child molester on the basis of that. So it's a quite literal interpretation of the Constitution. Somebody like Antonin Scalia does not believe in implied rights within the Constitution or unenumerated rights. This is particularly important when it comes to issues like abortion. There is no specifically listed right to abortion or a right to a woman's right to choose. But earlier cases have established that there is a right to privacy, and that has later been interpreted in cases like Roe versus Wade to include privacy when it comes to a woman's right to choose whether or not to terminate her pregnancy. This would be total anathema to the judicial philosophy of somebody like Antonin Scalia. The way Tubin puts it is that if the Constitution does not explicitly create a right, it does not exist. So if the Constitution does not explicitly say there's a right to privacy, or if the Constitution does not explicitly say there's a right to abortion, that right does not exist. A close cousin to textualism is called original intent or originalism. This is a little bit different. Textualism is a philosophy that says you need to interpret the actual text of the Constitution as it was understood by the people who ratified either the Constitution or the amendments at the time. Okay? Originalism, or original intent, says that the words of the Constitution must be interpreted as they were understood by the men who wrote and ratified it. So this puts a little bit more emphasis on the people that actually wrote the Constitution or who wrote the amendments. This perspective requires pretty heavy reliance on historical documentary analysis. For example, somebody who takes the originalist perspective would want to look at Madison's notes at the Constitutional Convention, the minutes of the meetings of the ratifying conventions for the Constitution and its amendments, and so on and so forth. But you are bound to follow the exact original meaning of the Constitution, with all the connotations that involves, with all the limits of the late 18th and early 19th century that entails. And this perspective is most often associated with Clarence Thomas and to some extent with Antonin Scalia on the modern-day Supreme Court.